Welcome, everyone, and thank you for joining us for this evening's program with Colorado Attorney General Phil Weiser and Colorado Public Radio Justice reporter Allison Sherry. I'm Claire Noble, Director of Programming for the Vail Symposium. On behalf of Chris Sable, our Executive Director, Dale Mosier, our Board Chairman, and our entire board, welcome. We're about to hit a really important milestone. We began operations in 1971, and we're getting ready to celebrate our 50th anniversary of convening locally and thinking globally. Two items to be aware of before we get started this evening. At the bottom of your screen, you'll see an option for Q&A. Please type your questions in there at any time, and we'll get to those questions later in the program, and we'll get to as many as time permits. Tonight's program will run until 7 p.m. It's being recorded, and you'll be able to find that recording at vailsymposium.org. I'd like to take just a moment to thank the organizations and individuals who've helped make tonight's program possible. Our sponsors include the Town of Vail, Vail Resorts Epic Promise, the Antlers at Vail, and the Vail Daily. Our virtual programs are sponsored by Alpine Bank. Cindy Ingalls and Leela and Walt Mischer have underwritten the summer season. Kathy and Neil Kimmel have underwritten the Hot Topics series. And the Vail Symposium is also supported by a generous grant from the Frechette Family Foundation. Thank you to all of our sponsors and donors. We couldn't do it without you. I'd just like to let you know about a couple of programs we have coming up. Our next program is going to be on Wednesday, July 7th. It features Ian Rosenberg, the author of The Fight for Free Speech, 10 Cases That Define Our First Amendment Freedoms. He'll be joined in conversation by Professor Rebecca Aviel of the Sturm School of Law at the University of Denver. And our first in-person program will be on Monday, July 12th. It will feature two career diplomats in conversation about diplomacy and foreign policy, Ambassador Christopher Hill and Ambassador Gary Grappo. Now we welcome Colorado Attorney General Phil Weiser. Attorney General Weiser is the 39th Attorney General of Colorado. He served as a professor of law and dean of the University of Colorado Law School. He held two clerkships at the United States Supreme Court for Justices Byron White and Ruth Bader Ginsburg. Journalist Allison Sherry joined Colorado Public Radio in 2017. She has more than 20 years of daily journalism experience. She began her career on the healthcare beat at the Denver Post and later moved to Washington, D.C. to serve as the Post's bureau chief. Among her many journalism awards, she was part of the team that received the Pulitzer Prize for breaking news while at the Denver Post and covering the Aurora Theater shooting in 2012. I just want to put in one last plug for, if you're going to ask questions, please use the Q&A option at the bottom of your screen. And again, we'll get to those questions later in the program. I'm going to turn the program over to Allison Sherry and welcome Attorney General Weiser.
Thank you, Claire, and hello, Mr. Attorney General. It's nice to see you. Yeah, you know, this is a tougher medium. I hope maybe next time we do this, we can all be together in the Vail Valley in person. You know, I've actually seen the general once in person since we've all been vaccinated, and he gave me a little news scoop. So, Mr. Weiser, you know, don't hold back on me here with the audience. If you want to toss me anything, I'm on vacation right now, but we have people in Denver working, and I'll send it to them. In hopes of keeping this conversational, I just kind of hope we can talk. You know, these are obviously complex subjects, and we're hoping to, you know, cover a lot of ground. And so, you know, I think you and I can be lively and fascinating and keep this moving along. So, you know, let's first start with the news. I know you know that this is the first thing I'm going to ask you about, which is, you know, yesterday a federal judge threw out big multi-state lawsuit against Facebook. Both the attorney generals have sued, you included, saying that Facebook was engaged in a monopoly, engaging in anti-competitive practices. Also, the Federal Trade Commission also sued, and the judge threw that out wholly, basically saying that it was a legally insufficient case and that the attorneys general waited way too long to sue based on their purchases of Instagram and WhatsApp. So That was a mouthful, but I wondered if you had a response to this tuss out with this federal judge, which kind of gives Facebook a giant victory in this space.
So the formal and less engaging answer is we're now digesting the opinion, considering our options. The longer answer, and I'm going to put in the chat, this is one of the benefits of this format, my testimony before Congress, where I talk about what enforcers need to do right now. My job as an antitrust enforcer is to bring cases, to marshal the facts in the law that I believe in, and ideally to move the courts to recognize anti-competitive conduct that violates Section 2 of the Sherman Act. This is a law that was passed 130 years ago. It's a simple law which bans monopolization. What I would suggest for everyone here to think about is if a company engages in I'm either going to buy off my rivals or I'm going to bury them, there's something wrong with that. That is a problem. If the court's attitude, generally speaking now, are informed by, and I'm going to get a little wonky here, the Chicago School of Antitrust, which means I'm going to assume that over-enforcement is the problem. And if we don't enforce enough, that's not a worry because the market will fix it. As an initial critique of antitrust law in the 1960s, as I explained in this testimony, the Chicago critique had some merit. However, as we're now seeing courts in a multiple number of cases, there was a case involving Qualcomm in the Ninth Circuit, which is another example we could cite, we're seeing a level of hostility and skepticism informed by the Chicago School of Antitrust. That's problematic. We have a more concentrated, less competitive economy today than any time in over a century. Lots of consumers on a daily basis experience this. When you want to buy an airline ticket, you don't have a lot of choices. Or when you want to use a internet search platform, you don't have a lot of choices. That's a problem. And it's a problem if companies are using their monopoly power to squelch competition and prevent rivals. That's why we brought the Facebook case. That's why we brought the case involving Google. That's why antitrust is one of my top priorities as Attorney General.
So, and with, I think that that's a very valid point to make, but, with all due respect, the judge completely disagreed with you yesterday. So what happens now? Do you try to refile? Do you try to make a better case? Do you think the case that you made was flawed, as the judge said?
I wouldn't bring a case if I thought it was fundamentally flawed and worthy of being dismissed on what we call a motion to dismiss. We believe that we are kicking the tires hard on patterns of behavior that is problematic, that deserves to be called out, that is a viable, as lawyers would put it, cause of action. What we have to figure out how we do well is make our case. Whenever you have a ruling you don't like, you have a number of options. We're going to consider those options and we'll go forward. I am playing a long game here. I am not about to give up on what I believe the people of Colorado entrust me to do, which is protect consumers and protect competition. We're going to keep doing that.
So we're all on Facebook, probably a lot of people on this who are listening to the symposium are on Facebook. Tell me specifically, give me like an example, if you can, not to totally put you on the spot, but it's sort of my job right now, of what you think, like if I'm going to scroll Facebook for 6 minutes while I'm sitting there waiting for a bus or something, like what would I see that is particularly problematic or anti-competitive?
Well, you're very good at your job, so it's always a pleasure to be interviewed by you. What I would say is the following. Users of Facebook right now don't have much of a choice. If you want to be on a personal social networking platform, you have Facebook or not much else. So what we have is, in effect, the policies that Facebook dictates, for example, on what type of privacy we get, or how much they charge advertisers, which then get passed on to us. That's not a healthy ecosystem. There was a time, and we detail this in the complaint, call it 2006, when MySpace was a robust competitor and alternative to Facebook. At that point, Facebook was on their toes. They had to offer better privacy policies. Maybe they were less aggressive offering advertisements. We want to have companies competing in the marketplace, having to offer a better product. And if they instead are a dominant firm who doesn't have to worry about competition and can undermine rivals through predatory behavior, that hurts consumers.
Do you think, though, that last fall we saw some new competitors rise up with Donald Trump being banned from Twitter? A lot of his followers went to Parler. They went to, I think it's called MeWe. I didn't write that down, so I don't remember that right off the top of my head. There was something else called Gab, I think. So there were some other, definitely not as big as Facebook. I mean, absolutely no way. I can't even remember them. That tells you how big they are, obviously. But we've also seen the emergence of TikTok. There have been some other things come in this space that I would argue, does actually present some challenges for Facebook. Now, maybe they're attempting to buy all these things right now, and I don't know it. But do you think that maybe there is some ingenuity here, or do you think that Facebook still just completely rules the market and it's bad?
Over time, we will know and we will see whether rivals to Facebook emerge. What concerns me and what motivates the complaint is over the last, particularly decade, Facebook singled out those most threatening would-be rivals and bought them off. Those they couldn't buy off, Vine comes to mind. They were founded by Twitter. They worked to deny access to key resources, interoperability, and data, so they buried them. The challenge for any would-be rival to Facebook right now is, will they be given fair access to data, data portability, interoperability to critical resources on the Facebook platform? As long as Facebook can play games, singling out some firms who are a rival to undermine them or to buy them, they will apparently do just that. That's why we brought this case, to stop that anti-competitive behavior and to protect competition.
And just to remind the viewers that the rivals you're referring to are Instagram and WhatsApp, both of which were purchased in, I think, 2014 by Facebook, 2013 or 2014.
In the early years, I think it was, yes, in that time period somehow.
Okay.
For those who are looking for additional reading, the complaint is quite lengthy and tells that story. You can find it on our website.
So I want to stick with this just for a little bit. The case against Facebook has been pretty bipartisan across the country. It's interesting. There's a number of interesting bedfellows in this space fighting against Facebook. Congressman Ken Buck, whose politics I'm sure you don't share a great deal with, is also pretty outspoken about the need for antitrust reform. When they say the word antitrust reform, what does that mean to you? That's probably more in the congressional space, less in the Attorney General space, but I do want to ask you what you think needs to be reformed with antitrust law.
I had the chance to visit with Congressman Buck and Congressman Neguse, who are, as you put it, strange bedfellows. But what unites them both is a shared commitment to protecting competition and consumers. There are a few areas that are ready for reform. The high-level message is the one I articulated earlier. We need to give courts the clear message that over-enforcement is not a core problem to be avoided at all costs. That's the Chicago school story I mentioned. Instead, we need more robust antitrust enforcement. When we look back in the airline industry, and take an example I mentioned in my testimony, what we see is over the last 20 years, almost no entry into the airline industry. That follows some bad decisions that were motivated by the Chicago school thinking. And those bad decisions really undermined a predatory pricing argument that was brought by the Department of Justice when I was there initially working for Joel Klein. He was the head of the antitrust division. And since that decision allowed predatory pricing, we haven't seen entry. Moreover, we've seen mergers in that industry such that consumers have less choice. The message to courts has to be, that's bad for competition and consumers. The same message, by the way, needs to be internalized by enforcers like myself. We need vigilance. I want to mention a case that is illustrative here. I mentioned the testimony. It's called Steves and Company. It's a case involving a company that makes doors. They're independent door manufacturer. They sell their doors like at Home Depot and the like, and they need door skins to make their door. Well, they had mergers down to only 2 providers of the door skins. And what happened? They started cutting off the independent door manufacturers and raising prices. That hurts consumers. That problem of increased concentration and decreased competition is something we're seeing more and more of. So what can Congress do about it? Several things. One thing in a bill that I wrote a letter praising Congressman Buck and Joe Neguse. Make sure state AGs are fully able to enforce the antitrust laws, that we're not actually marginalized as players. We need more officials standing up for enforcement. State AGs were given a lot of authority in an earlier congressional act called the Hart-Scott-Rodino Act. We need some additional protection so we're on all fours and a respected enforcer, just like the feds. We also want to make sure there's enough funding for the feds to both do enforcement and do retrospectives of cases like the Steves & Company case I mentioned. And finally, we need to give the message to the courts not to be so skeptical about some of the sorts of cases that I've mentioned. Instead, to recognize we have got a major problem on our hands of not enough competition in our economy.
So it seems like what you're saying is it doesn't necessarily mean reform, like there needs to be a bunch of new laws that need to be passed around antitrust. It's that you need to have more teeth, more resources, a beefier consumer protection, I'm sorry, I'm forgetting the consumer, the acronym I'm thinking of. Elizabeth Warren used to lead it.
FTC? Federal Trade Commission?
No, the Consumer Protection Bureau. Anyway, what I was going to say was that there needs to be more teeth and resources behind enforcing existing laws, not necessarily that there needs to be new laws passed. Is that correct?
The only slight addition I would mention is in some of our existing laws, Section 2 of the Sherman Act, for example, I think there could be some clarifications on the appropriate implementation of them. So I mentioned, for example, the predatory pricing issue in a case that went against the Department of Justice and in favor of American Airlines. That decision, I believe, is wrong and should be overruled. And so there is some room to clarify the appropriate standards under Section 2. But in the main, to your point, Allison, I would not disturb the basic architecture. We have these really majestic antitrust laws that are short and are to the point and have been interpreted by the courts. The problem we have mostly right now is we've seen some courts acting with a undue skepticism towards enforcement. With a few clarifications, I think we could see what you might call a congressional brushback pitch to the courts to say, guys, you're crowding out antitrust enforcement. You need to give it a little more room.
I'm sure you put this recent judge's ruling in that category.
We're still studying it, and so I won't characterize it just yet.
Okay. I like that you called that law majestic, by the way. You're such a lawyer, right?
It is majestic. I mean, here's the thing. The Antitrust Act of Sherman Act of 1890 is written on a few pages with grand phrases like barring restraints of trade or monopolization. That is a thing of beauty, and antitrust lawyers have learned to love it.
I love it. So I'm going to go down. I have one more Facebook question, and then we're going to move to Google. And I'm going to go down a little bit of a rabbit hole, but I think it's an interesting rabbit hole, which is about algorithms and the Facebook algorithms. And you and I have talked about this before, Mr. Attorney General. How there's some infamous Facebook algorithms in the 2016 election that led Russians. They were able to actually get in and purposely purchase ads that were fake and promoting false fake news, purposely inflammatory, purposely divisive for our democracy. A lot of that has come out in the last 5 years. Facebook, in light of several congressional and government investigations, has vowed to change this. And, interestingly, what it has done for the news industry, which is what I'm in, is when we used to put up articles, real news articles, CPR News only does real news articles up on Facebook, we would get a lot of traffic from it. People would see our stories, they'd comment on it. If it got commented on a lot, it would get, elevated higher. And so the news business started to rely a little bit on Facebook for internet traffic, which, because of online ads, is an important measure for us to make some money, not a ton of money, but some money. But what happened was when Facebook changed their algorithm in light of the Russian bots in the 2016 election, they started de-emphasizing news. So it's harder for us to get high up, even real news. And they started trying to promote more family photos and they had this whole ad that was like, it's the old Facebook that you remember from the past. I wondered what your role, the federal government's role, not sorry, not the federal government, any government, your role as an attorney general or the federal government's role would be in regulating algorithms, if that's even possible.
Few different answers. First is if we had competitive platforms, and Facebook was only one of them, the decision of each platform would be less consequential. This is why the Colorado Springs Gazette, which leans pretty right, has been very appreciative of my leadership on antitrust, because in a world where you have dominant control of information, there are going to be concerns about how different viewpoints are treated. That's not healthy from an information ecosystem perspective. Secondly, and I'll put another speech of mine in the chat, which I gave to the College Judicial Institute, we all should be worried about the state of our democracy and the state of people's getting information that is leading them to be operating in separate worlds from one another with more and more demonization. We need news outlets like Colorado Public Radio that tell it straight, inform people, let them make up their own opinions. If instead you're trying to give people facts that are made up to cater to what people already believe, whether the election was fair or stolen, to take a notable recent example, that's not healthy. And we need to create more space where people can have shared facts and then civil and respectful discussions. To the extent the algorithms encourage demonization or hating or people refusing to listen to one another, that's a threat to democracy. And I am working on a project as the incoming chair of the Attorney General's Alliance, which mostly has Western AGs, but open to others. How do we work together in a way that models the type of engagement we saw from Justices Ginsburg and Scalia? And I worked for Justice Ginsburg when she was very much intellectually engaged and friends with Scalia, even though they disagreed. We need that mindset. Ken Buck and Joe Neguse, as you mentioned before, or myself and other Republican state AGs, including some I'm working with on this Google case. That is the way our nation, our democratic republic, is at its best. And finally, can governments, as opposed to, let's call it citizens or norms, do something directly? Here we're in a very difficult space because of the First Amendment. And the problem with speech and regulating or preferring different speech is the government risks picking sides, and the government is not necessarily well set to do that. And even as Facebook has to decide how to handle different information, it is in a difficult position. I'll give you an example that we all are thinking about now, which is, to what extent is it possible that COVID-19 came out of a lab in China? That was floated a year ago, and there was an article in the New Yorker about it. And a lot of people were like, oh, we can't believe that because Senator Tom Cotton suggested that was a possibility. That's not a good reason to believe or not believe anything. We should take ideas, analyze them on the merits, and if a good idea comes from any political party or person, it should be analyzed on the merits. That, unfortunately, is not necessarily the world we're always living in. That's the world we need to get back to.
Do you have a sense, you brought up the Supreme Court and a couple of justices and a former justice. Do you think that the High Court will eventually have some say or a role here? I mean, no, I'm asking you to predict the future, but do you think eventually this is going to have to be settled?
With respect to the future of antitrust law, the Supreme Court is absolutely going to be making decisions. And part of the challenge is the Supreme Court hasn't made many decisions in antitrust law. There are not a lot of precedents. So we're looking at Section 2, for example. One of the most important precedents is a case from the early 1980s from here in Colorado called the Aspen skiing case, which involved a company that owned 3 mountains in Aspen and decided to engage in discriminatory, unfair conduct towards a rival who owned 1 mountain. That was judged to be a violation of Section 2 of the Sherman Act. It's a leading precedent today. The second leading precedent was a case that came about 20 years ago called Verizon versus Trinco. I had worked on that case on the losing side. Verizon won. They were accused of denying interoperability in a way that violated Section 2 for a whole series of complicated reasons. Verizon won that case. If you're looking at 40 years of economic history and you ask, how many important Section 2 precedents are there? And the answer is 2. That doesn't seem like Supreme Court has been deeply engaged in this conversation. So yes, they will need to get engaged. The Microsoft case might be a third important precedent. That was not decided by the Supreme Court, however, so it is still an important one, but not a Supreme Court precedent. With regard to the issue around speech and Facebook, the challenge is the First Amendment says the government doesn't regulate speech with an eye to picking what speech it likes, what speech it doesn't like. Facebook has created their own, if you will, Facebook Supreme Court, which reviewed the decision to bar President Trump from the platform. That's because they're a private company and they've got to make those decisions.
Yeah, I mean, I think that's where this is interesting because I'm asking you what the government's role is in regulating a company and how it decides to use its own algorithm, which, I think on its face, a lot of people would say there's no role there, but
Well, I do want to mention one other point, Allison, because you're probing an important issue. You could imagine governments demanding transparency, because transparency is not dictating speech. It just says, if you're putting a thumb on the scale and you're showing people certain types of speech and not others, tell them. If there was a social networking platform that said to people, we have algorithms that dictate what you're going to see, would you like to see lots of different types of ideas so you can make up your own mind? Or do you want us to feed you ideas that drive you further and further into one corner? That would be a
created by a
question.
Russian bot.
There you go. So that would be, an area that I'd love to see more discussion about, because you've mentioned this point about algorithms. I'm guessing even a lot of our viewers here I know are super smart, aren't necessarily fully even aware or haven't analyzed critically that what we're seeing on these platforms, it's not just sort of a automatic thing. It's dictated by these algorithms, which have certain consequences to them.
Right. Absolutely. And I think people probably maybe have noticed it too. I mean, maybe some changes. And it's interesting to think that Facebook, you could log in and you could actually have a survey or a 5-question survey. And it's like, what would you want to see more of? I don't know if that makes it more transparent. I guess it gives you a little bit more choice as a consumer.
Well, as someone who protects consumers, I care a lot about transparency. It's worth giving a plug here for Colorado. We just passed the 3rd law in the nation that gives consumers protection in their data privacy. If you don't want your information to be used in ways where you're tracked and that information is sold to others so you can be marketed, you have now the right to opt out. And our office will be working on implementing that. And that's an area where, again, consumers may not even realize that is happening. We want to create that awareness and give consumers that choice.
Yeah, you jumped ahead. That was going to be a question right after I asked you about Google. But now that we're on the subject, can you give the listeners and the viewers some example of the state law that just passed and how that would affect their lives? Like a real life example of something.
All of us are using online services of different kinds. Kind of like the algorithm issue we're just talking about. A lot of us aren't even thinking about the fact that our information is all being captured, stored, and sold to so-called data brokers so that we are going to get marketed products based on data about us that get sold. There are protections in narrow areas, healthcare data, for example, financial data. But a lot of the data that we are entering online is going to be used in ways that we probably wouldn't want if we knew about it. So this law says to every company that collects data, which is a lot of companies online, you need to tell your customers that you collect data and that you store it and that you may sell it. And if they want to opt out from that, they have the right to do that. So
is that like, I'm sorry. I was just going to bring up just an example. So when you're on a website and it says you do accept the cookies, is that what that means?
So that's slightly different.
Okay.
Cookies means they're tracking where you're going online.
Okay.
What this is going to say is something more like, as a company, we collect data about what websites you're on, what you're buying, what you're looking at. We then sell that to third parties who may use it for marketing purposes. If you do not want us to do that, click here for an easy opt-out.
Wow. So that if you're a Colorado consumer living in Colorado and online shopping, companies, you're going to have to figure out a way to make that enforceable. So companies are going to have that pop up if you're sitting in Colorado because it's a state law.
You've put your finger on one of the elements here that's slightly uncomfortable. In the first best world, we'd have a federal law that would protect privacy. As it turned out, a decade ago, I was working for President Obama pushing that idea. A decade later, with no federal action, Colorado has said, and in our state Senate, this passed unanimously. So this was not like a controversial topic.
Right.
All across the spectrum, people in Colorado and their representatives are like, we want control of our data. We want the right to opt out and not have it sold without our consent. It should be national. That would be easier for companies to follow. But unfortunately, our legislature is not functioning at the national level the way it is in the state level. So we're still waiting.
Right. Interesting. Well, I'm excited to see how that is implemented. I will probably do some stories about that. I think it's very interesting. Let's shift just to Google. We talked about Facebook so much. I don't want to ignore Google completely because I know that you're mad at them too, and you have filed a lawsuit. What's your concern sort of broadly about that search engine and how it negatively affects consumers?
I should say, I don't take any of this personally. Google has the right to decide how to conduct its business. I have the right and obligation to decide if it violates the antitrust laws. If they think I'm wrong, they can oppose me in court, and the process will play out. What I have observed with Google is what I observed with Microsoft. I mentioned before I worked for Joel Klein, who I know a few people on this Zoom know well. He is an extraordinary lawyer and person, and he was the architect of the Microsoft case. What the Microsoft case established was Microsoft is not allowed to basically cut off the air supply of rivals. And that, by the way, was a quote from Bill Gates about Netscape, who had a Navigator product. The Netscape Navigator threatened to basically undermine the operating system as something consumers needed, because if you got all of your applications on top of your browser and not on top of your operating system, you might decide, I don't care what operating system I have. That threat was one that Microsoft took seriously, and they proceeded to enter into a range of restrictive contracts that sought to cut off their air supply, limit their distribution. They sought to create a lack of interoperability with their platform so that Netscape's product wasn't as functional or as effective. And they generally sought to handicap their rival. Google has also identified threats from different vectors, if you will. One of them is the Internet of Things. If everyone is using voice-activated search technology, and your specific search engine is not what you're picking, that can be a big threat to Google. So what's Google done about that? It sought to lock up all the distribution channels in connected cars, making it impossible for a would-be rival to get a foothold there. Similarly, Google knows that these so-called vertical services like a Yelp could be the basis of a rival search engine platform. So they've sought to undermine their position in the marketplace in a systematic way. That type of predatory campaign, preying on rivals, not competing on the merits, violated the antitrust laws in the Microsoft case. We believe it violates the antitrust laws in the Google case as well.
When you say the cars, are you saying that they have locked in? So if you are using your voice activated in a car to search for an address of a restaurant, for example, when you're driving, Google controls that. Is that what you're saying?
Yes. And just to be clear, this is Google's second time around. When the world transitioned from the desktop to mobile, Google locked up mobile distribution by having restrictive contracts with the mobile broadband providers, as well as with Apple, the other main platform. Google, of course, controls Android, one of the platforms. And so Google locked up the mobile ecosystem so that rivals couldn't enter effectively with mobile search. Now that we're in Internet of Things search, with cars being a notable example, they're doing the same thing.
That's interesting. And the auto manufacturers are kind of just going along with that.
This is an example of what monopoly power looks like. When you have both the money and the influence in the market such that would-be partners like auto companies or AT&T and Verizon on the broadband side basically feel they have no choice but to go with you, that's an example that you have monopoly power, that companies feel like they can't say no to you. And Google's been willing to use that monopoly power. They've also told those auto companies, you want to use Google Maps, you have to use Google Search as well.
Interesting. So that was a case filed with, I think there were 49 attorneys general filed a suit against Google. Is that correct? Is it still around?
So to be, you're being accurate, and to be precise, I would say there were two separate cases. If you add them together, I believe the number is 49.
Okay.
38 were on the case that Colorado led with Nebraska. And then I believe 11, I think that's right, joined the Federal Department of Justice in a parallel case. The vision is the two cases will be working together in tandem. And we have a trial date for September 2023. So we've got some time before this gets to a courtroom.
Interesting. I don't think I knew that it was set for trial. Where is that going to be?
It's in the District of Columbia. To be precise, again, there is an opportunity for either party to move for summary judgment, which would be a decision before a full trial. That is theoretically possible. If it goes to a full trial, as happened in Microsoft, that will be September 2023.
So there are about 5 minutes left, and we're going to take some questions from the audience. I wanted to see if there are a couple of other sort of topics that I wanted to get to that don't have to do with this. And I wanted to, maybe ask one or two of these questions and then let the audience ask you some questions. And maybe I can do a last minute, lightning round or something if we have some time. But the audience always has great questions, so it'll probably take us all the way up to the top of the hour. I do want to ask you about an update you may have on the opioid settlement money. Colorado received in February, I did a story about it. It was $10 million for Colorado from pharmaceutical companies.
McKinsey.
It was McKinsey, that's right. It was a $570 million settlement nationally. Colorado got a 10 million chunk of change from that. It's been 5 months-ish since that money. I don't know if you've gotten it yet, but any sense of where the money is going to go in the state?
Thank you for asking about that. The framework we are building is going to be a regional framework. The money that will be spent on a regional basis. And so we are in the process of working with local government actors to develop what that looks like. And the idea is we'll have a set of regions with their own governing bodies to get the lion's share of this money and to spend it to serve a range of efforts that will serve those communities. Drug treatment, drug recovery, education prevention are top of those lists. We're also going to work with some of that money at the state level that we would spend for statewide concerns, like how do we get more people in the workforce to engage in behavioral health, particularly for a lot of our communities where they're suffering a real workforce shortage. The first money, as you note, is in the door. We do have the check. There are some other settlements that are coming close in. The New York Attorney General just settled that state's case against Johnson & Johnson. We are going to be working towards national settlement, we hope, as well, with Johnson & Johnson, as well as others. There's a litigation going on in bankruptcy court involving Purdue Pharma and the Sackler family. We've been very active in that case as well. The goal will be towards the end of this year, not just this McKinsey settlement that we led, but these other cases, to have the money eligible, and then we'll have to work up this plan I mentioned so that we're ready to put it into motion. So the second half of the year promised to be an important time as we conduct this work. I want to give you a shout out because I often told people what a big problem this was. And in the San Luis Valley, for example, 90% of the people who are in the jail in Alamosa County were addicted to opioids. And the sheriff there was frustrated because he wasn't really addressing the problem. People didn't believe that story until you told it for CPR, and your credibility and track record led people to think twice. This is a major challenge. It's also a challenge that we're not going to have as much money as we need. We have about 30% of the treatment we need in Colorado. This settlement fund will be valuable. What we really need is to use other funds as well so that we make this critical front-end investment in better treatment, recovery, and education and prevention. If we can all be more mindful of substance abuse disorder and mental health issues more broadly, I think we can better support one another.
Just a very quick follow-up on this. When you say like the San Luis Valley, both of us have been down there a number of times. I know you want to concentrate some resources there because the problem was so bad there. would that be rehab centers? Would that be bricks and mortar, like a new building? Or would you have are there existing resources, like just helping the sheriff with a couple of staffers who could, maybe help with the treatment piece and not just cycling these people in and out of jail who are addicted? What is it? I mean, are there any examples you can give that would kind of...
So literally, this is a whole nother hour conversation we can and should have, because if you go across the state and ask this question, you're going to get a lot of different answers. Part of what I think we're going to see in Colorado is a range of experiments. And one of our goals is to best nurture, support, look over, and share results. So yes to everything you said. Some parts of our state says we're going to build a inpatient drug treatment center. That's what we really need. Others will say we need more recovery support, so after people are an inpatient, they stay clean. Other people say we need more trained professionals who can be in the jails and other places giving people medication-assisted treatment. Another one says we're going to use more telemedicine approaches that are going to help people in these centers get access to trained addiction counselors, and everything else that you can imagine to address what has been a true crisis. When I went to the San Luis Valley talking about the future of the Valley, I wanted to talk about agriculture or the outdoor rec economy or other job opportunities. And what I heard back is we're not going to have a bright economic future until we address this opioid crisis.
Right. I'm going to switch. I'm going to do one more question, different than opioids, and then I'm going to hand it over to Claire. It's about police reform. You've been active in this space about the need for criminal justice reform. Colorado's legislature has passed a number of criminal justice reform bills in the last 2 sessions. Even the brief one during COVID, they passed a sweeping police reform bill. It's still taking effect in stages right now. And then this last session that just ended a couple weeks ago, they passed a number of different bills. I think there were some 15 to 20 criminal justice reform bills. One requires people who get jailed to get a bond hearing within 48 hours. There are a number of them. In this space, Mr. Attorney General, what do you think needs to still happen in Colorado?
Well, first, I want to give a shout out to the police chief, Greg Daly, in the town of Avon. He's on our Peace Officer Standards and Training Program. And he, like many other volunteers, are committed to elevating policing. Part of what we have seen, and I would underscore, is this is a really hard job. And what we need to do is give police the tools, the training to be effective. I went today to, people can see it here, Gordon Beasley's funeral. He was the officer shot in Arvada. And he represents that profession at its very best, with a commitment to serve, and in his case, with extraordinary empathy. Part of what we need to do is recruit and train police officials in the best way we can. And so in terms of what needs to be done, number one, raising the quality of police training. I'm putting up a blog post. We talk about that. I know we can look forward to more reporting on that topic as well. Another point that's important is we need transparency and accountability. Part of the challenge for all institutions, prosecutors, judges, law enforcement officials, the Catholic Church, is if people don't know what's happening and they don't believe there's accountability for irresponsible and wrongful conduct, that brews distrust. What some of the laws you mentioned speak to is creating databases, for example, of officers who are decertified for lying. And that's important that the public know that there is accountability and we're transparent about that accountability. We also in our office have another accountability mechanism called the ability to do a pattern and practice civil rights investigation. If we have a police department that violates civil rights of citizens on a systematic basis, that's a problem that has to get fixed, and there needs to be accountability to own and address that issue. As you note, policing is one of the most important issues because we need more police like Gordon Beasley, who happened to be a student resource officer. I've heard about some student resource officers in Vail. I've heard about them in Craig, who again, lead with empathy, build relationships, and come from a spirit of service. We will figure out in Colorado, I believe, how to do this the right way. And in so many issues we've talked about today, antitrust, privacy, the opioid epidemic, and policing, I'm proud of Colorado and how we do things. We are collaborative problem solvers here, We've got some big challenges, but we can meet them.
And I just want to point out, in case people don't know, the police officer standards and training is in your department. And it's what every officer needs to pass to be certified as a peace officer in Colorado. I just wanted to make sure people may not know.
Yeah, this is not always intuitive, so thanks for filling it in. We oversee this board. It's part of our office. It is, in effect, the licensing body. If you're a police officer, we have expectations for your training, for your ongoing training, for your behavior, and that certification regime is managed by our office.
There is one police department under investigation right now for patterns and practices violations, perhaps, and in your department, Aurora PD. And I wondered if you had any updates on that.
It is ongoing. We're soliciting community engagement, other information. The way this process works is we do our work, and if we are finding concerns, we will document them in a report. And then the city has the ability to either engage with us and say, we got it, we have work to do, and we would have a consent decree, an agreed upon framework for addressing the concerns. Alternatively, if they disagree, they have the right to litigate, and it would then get litigated before a judge.
I'm handing it to Claire to take the, I'm sure, probably better questions from the audience than me.
No, thank you, Allison. You've been doing a great job. I do have some questions, and this one is somewhat related to what you're talking about right now. So I'd like to go to David's question first. He said, thinking about more effective gun regulation to protect Colorado residents from, in particular, mass shootings that have been all too commonplace since Columbine. But how do we politically achieve that while also navigating Second Amendment issues?
I want to start with the Heller opinion by Justice Scalia, which outlines the Second Amendment standard. It is not the case that any single person, no matter if they're mentally ill, if they've committed a felony, if they're otherwise a threat to public safety, has a categorical right to a firearm. There can be reasonable restrictions of firearm ownership consistent with the Second Amendment. By the way, there can be reasonable restrictions on speech consistent with the First Amendment. Think about you can't yell fire in a crowded theater. And what we did in our extreme risk protection order law, often called the red flag law, is create a framework that gave a tool to law enforcement. If someone is a significant risk to themselves or to other people, you can remove the firearm and thereby address the threat to that individual. In some cases, it might be someone's willingness or interest in killing themselves. And we should note more gun violence deaths happen by suicide than by homicide. Part of the challenge, and I think this gets to the spirit of the question, when the issue is framed as the government's going to take my guns away, gun owners get their backs up. So from a both constitutional law perspective and from a public discourse perspective, that's the wrong frame. The right frame is, how do we make sure that we honor responsible gun ownership and we address those individuals who should not have a firearm having one and able to do massive damage? The red flag law, I believe, follows that principle to a T. The red flag law does not impinge upon responsible gun owners having the right to have their weapons. It says if you are a significant risk to yourself or others, we can remove that weapon. There are a range of other measures that I believe are consistent with this approach, including responsible gun owners should be engaged in responsible safe gun storage. Another one is if you are a known perpetrator of domestic violence, you have to make sure you relinquish your firearm. And you can't just hold on to it while a case is pending and there's a protective order against you. We addressed both those two issues in the most recent legislative session.
So I want to circle back to Facebook. This question comes from Pete. And he says, you know, there's no question in his mind that Facebook is a monopoly, but there aren't any real competitors. So wouldn't that make it less useful to consumers because now all of their friends aren't in one place?
Here's the alternative view for Pete. Would you rather be in a world that had only Uber or only Lyft? Or do you like having both Uber and Lyft? I believe having choice between different platforms where people can be on more than one platform, and drivers, by the way, could be asked the same question. Do you as a driver like being able to be on both Uber and Lyft? And I think most drivers would say yes. So we want to be in a world with, to my mind, choice. Consumers do better when there's choice. The fact that there's currently no choice, I don't think should be used as a justification for maintaining that world. And even, by the way, if there's the threat of competition, that can make a difference and discipline companies and keep them honest.
So this is a little bit off topic, but I think it's an interesting question. So I hope you don't mind if I'm sharing it with you. This question comes from Beach. If Amazon attempts to merge with a major delivery company, such as UPS or FedEx, should it be blocked? And if so, under what theory?
So Ty is a ringer. And for those who are in the weeds, you will recognize the question gets to what's called vertical mergers, which means a merger at two different levels of production. So let me first answer the question by telling something that we did here in Colorado that explains why there is a theory that explains that vertical mergers can be problematic. In Colorado Springs, there were three major providers of Medicare Advantage, and a number of people who are in that marketplace know that, again, competition is good for consumers. If you've got three providers offering you different products and services, that's better than two and definitely better than one. The concern was there was a dominant firm. The dominant firm was United Health Group. They actually had been even more dominant, and they were losing market share to Humana, who had been the upstart. And so United Health Group said, we're going to buy, this was DaVita's practice groups, who had been referring to Humana. And DaVita said, uh-oh, they're going to stop our referrals and only refer to themselves and push us out of this market by denying a critical source of referrals. The case, and we looked at that and said, that concerns us. We told the companies, if you don't do something about this, we're ready to sue. They said, we've got some pro-competitive commitments we can make that will address your concern. They offered them to us, we accepted them, and there's a consent decree in place to protect competition and protect consumers. In this case, the worry is because Amazon does so much shipping, if you ended up having Amazon buy a shipping company, would they diminish from rivals the ability to have access to a shipping company? And I'm sorry to give you the typical lawyerly answer, but we'd have to do the work to understand the facts to see whether that theory held water. In principle, the theory that a vertical merger can harm competition is a solid theory. See the case I just mentioned. Whether that theory would apply in this instance, I can't really address in the abstract, but we would certainly look at it.
So this next question is kind of deals with the law of unintended consequences. And what made me think about it was when you were talking about this privacy law that Colorado has enacted for the benefit or protection of Colorado consumers. But Colorado's Equal Pay for Equal Work Act went into effect. But what is happening now is some out-of-state job listings are specifically excluding Coloradans. How is that even legal?
The short legal answer, which I know is not satisfying, is every company decides where they want to do business. And if they say they're not doing business in a particular jurisdiction, they're not subject to the laws of that jurisdiction. So for example, we have sales tax here in Colorado. If a company says, I'm not going to sell in Colorado, I'm not going to ship there, I'm not going to open up a store there, they don't have to pay our sales tax or any other laws that govern those who sell here. If you're an employer and you say, I'm not going to hire any employees in Colorado, our employment laws don't apply to you as a private company.
You're right. That's not particularly satisfying.
I'm sorry. You use the phrase, the law of unintended consequences, and I will say the challenge sometimes is people say, shouldn't there be a law against that? That seems wrong. And then you may govern the particular behavior, and then people find a different way to behave that doesn't necessarily address the issue you were focused on, which means in many areas of the law, we don't have the luxury of just passing a law and then tuning out. We have to stay engaged. And I think Allison's point about the privacy law is a good example. We passed a law. Now we're going to have to adopt regulations, see how it works in practice. And if consumers aren't actually benefiting by getting control of the information, then something isn't working. We've got to stay engaged and figure it out.
Well, Allison, we have about 5 minutes left. I know you had some more questions for Attorney General Weiser. Did you want to proceed to your lightning round now?
Sure. Lightning round. Does that mean that I have to be lightning, or does that mean that
It means I got to be lightning. You get to ask me a lot of quick questions and I got to answer quickly. Like movie recommendations.
Sure. I want to actually, you can answer this quickly or longly if you want. I'm just joking. You've mentioned, and this is kind of going back to the antitrust stuff again. You've mentioned a couple of examples of bad behavior in sectors. You mentioned the airline industry. Obviously, we talked about Google and Facebook for a long time. You've mentioned to me some good examples of good antitrust behavior in streaming services. You've mentioned, because you can get a device, an Apple device, or you can stream it on your computer, or you can get a Roku, and you can buy all these different kinds of Netflix and Hulu and whatever you want, and you can stream whatever you want, and they're all competing right now, and they're trying to have the best movies and whatever. Amazon is in there. You mentioned that as a good example, correct?
Yes.
So
it gives lots of choice for consumers which streaming service you want to sign up for.
That's true, and lots of options. If you don't want one because you don't like Amazon, for example, you don't have to miss all the good stuff. You can get Netflix or whatever. If you could give me one or two other sector examples, I'd love to know where else this is very healthy in our economy right now.
Well, first, I want to give an example that's historical but directly on point. When the AT&T case was brought and settled with the consent decree, there was a major change. Before the case, Dow Corning wanted to sell fiber optic cable to AT&T, which was then a monopolist. And AT&T said, we're not going to buy fiber optic cable from you. Whenever we finish depreciating our copper network, we'll do it ourselves. And then that was going to be like 10 or more years away. After the litigation ended and Sprint and MCI had a chance to compete fairly, they bought fiber optic cable. Sprint, some people may remember, ran a commercial that you could hear a pin drop on the Sprint network, but you couldn't hear that on the AT&T network. AT&T immediately, after that commercial, wrote off their copper network, placed an order for fiber optics, and improved their product. That's what competition looks like and brings to consumers.
So that's a little bit older. Is there anything at current, except for the streaming services that you've mentioned before, that's operating in a great competitive space? Except for crab cakes, which is, right now I'm on vacation on the Delaware beaches, and there's a crab shack every 10 feet. So
well, I think food, listen, I'm going to stick with the food idea because here in Colorado, and I am a connoisseur of casual fast food dining, think about how many Chipotle, Mad Greens, Cava, there's all sorts of these casual fast food operations trying to give you better casual fast food dining experiences. Panera, you go down the list. That's a competitive market. If you're looking for a place to eat lunch in downtown Denver, you've got a lot of good choices. That means no single firm can take their position for granted. They need to be on their best behavior, provide the best product for the best price.
And if Chipotle decided to go buy 10 of those companies, you'd be suing them.
One of the questions here, though, is going to be barriers to entry. If I knew tomorrow someone else could come right in and provide new offerings, then I would probably lose that case because there is not enduring market power. That's part of the question. In airlines, those mergers happened and we've not seen entry. That's a sign there's enduring market power. That's what hurts consumers.
And my very last thing a point that I'm going to make is you on the airlines point went after Frontier Airlines during the pandemic, and you can talk a little bit more about it because they were not being flexible. A lot of people had flights booked, obviously, and they all got canceled. Vacations got canceled because of the pandemic. And a lot of airlines were, giving refunds or credits or whatever, and Frontier wasn't honoring all of those. And so you went after them. You can take it from here.
This is an important thread. I really appreciate you pulling it through. If you're a company who's in a dominant position with limited competition, you don't have to be on your toes. You can take advantage of consumers. Exhibit A, during the entire pandemic, we got complaints about all sorts of companies who engage in all sorts of practices. We got money back for consumers from summer tours, from concert venues. The most complaints we got by far, Frontier Airlines, because they did what you said. They refused to give people credits. They made it hard to honor the credits so that people who had booked flights ended up losing the money and not getting what they paid for. Because of a screwy quirk in the law, it's up to the Department of Transportation to oversee and protect consumers in the airline industry. Myself and 40 other state AGs have pushed Congress to change that. But right now, all I can do is push the Department of Transportation to take action against Frontier because that's the preeminent overseer and they have yet to act in this area. We'll stay on it.
Okay, interesting. I didn't know if that had been resolved. So it sounds like it's still pending.
We're staying on it.
So we are out of time. I want to thank both of you very much. Allison, thank you so much for doing the hard work of being the moderator tonight. Attorney General Weiser, thank you for both being in our program, but also looking out for Colorado consumers and residents. We certainly appreciate that. For our audience at home, thank you so much for joining us this evening. I hope you'll join us next week on July 7th, where we have a program focused on freedom of speech. Good night, everyone, and thank you.